The Apple Siri system is still logging your voice right now, and GDPR can't stop it. Your device heard you. It transmitted a telemetry handshake to Apple's servers before you finished your sentence. The Irish Data Protection Commission had 3 years and full legal authority to shut this down. They issued a fine. Apple paid it. The recordings kept running. Today I'm exposing the specific retention architecture Apple never disclosed and why the regulator already knows it can't reach it. Here's what Apple says Siri is. It's a voice assistant, a convenience feature. You ask it a question, it fetches an answer, the audio is processed and discarded. That's the official product description. Apple built its entire privacy reputation on that framing. They ran campaigns about it. Tim Cook testified about it. The promise was simple: your voice query lives and dies in the moment. No persistent record, no profile. The audio was yours and it stayed yours. That's what they told regulators. That's what they told you. Neither statement was accurate. In 2019, a contractor published what he'd been doing at work. He was listening to Siri recordings, not a few thousands per shift. Audio captured when Siri activated accidentally. Inside bedrooms, inside doctors' offices, inside conversations the owners believed were completely private. Apple called it quality review, standard industry practice. The recordings weren't linked to your Apple ID, they said. They were anonymized. They were safe. What they didn't say was what happened after the review, because the review was never finished, and the recordings were never truly anonymized. Each audio snippet carried a persistent identifier, a device-linked token that cross-referenced against Apple's behavioral data points directly back to you. Apple's documentation called it a random identifier. It wasn't random. It was generated from device hardware parameters. It was stable. It was yours, and it's still running. The Irish Data Protection Commission opened its investigation in 2019. Ireland matters because Apple's European headquarters sits in Cork. Under GDPR, the Irish DPC is Apple's lead supervisory authority for all 27 EU member states, 450 million people, regulated through one office. The DPC investigated for 4 years. They concluded Apple violated GDPR's data minimization principles, collecting more than necessary, retaining longer than disclosed. The fine, €13 million, for a company clearing $10 billion in profit per quarter. Apple absorbed it, adjusted a privacy settings checkbox in Europe. The underlying retention infrastructure was never addressed in the ruling, because the ruling never reached it. Here's the part nobody reported. The regulator already knew it couldn't stop it. The storage architecture sits outside direct GDPR enforcement reach, not through malice, through law. When Apple processes a Siri query, the audio is routed through a CDN edge node before it ever touches Apple's named servers. The identifiable elements, the query, the persistent identifier, the device ping, are stripped at the edge and reassembled downstream inside Apple's analytics pipeline. GDPR enforcement targets the data controller. Apple designates the edge node as a processor, operating under a separate legal instrument. The DPC's ruling focused on the controller layer. The analytics pipeline, where the persistent identifier reassembles alongside behavioral data, operates under a different legal classification. The fine hit one layer. The storage runs on another. Same company, different legal treatment. And that gap is exactly where your voice lives. Go back to that opening fact. Your device transmitted a telemetry handshake before you finished speaking. That handshake included a persistent device identifier. It has never been rotated. Every Siri interaction since, every accidental trigger, every query in a private moment, has been threaded onto that same identifier inside Apple's infrastructure. GDPR gave you the right to request deletion. Apple honors that request at the Apple ID layer. The analytics data, held under the persistent identifier, falls under a separate retention policy Apple classifies as aggregate research data. Your deletion request doesn't reach it. Right now, somewhere on Apple's servers, there is a record linked to a persistent identifier tied to your specific device. You didn't consent to it deliberately. It was assigned years ago during a routine Siri initialization. Every accidental trigger since has appended to it audio from rooms you considered private, conversations that happen near an unlocked phone. GDPR gives you access rights, correction rights, erasure rights. Apple's compliance team honors those rights at the Apple ID layer. Persistent identifier layer operates under different governance, different retention schedules, a different legal classification. The Irish DPC never compelled Apple to produce documentation of what's stored there. The €13 million fine closed the formal investigation. The data didn't move. Apple's privacy page still reads the same way it did the day before that fine landed. Trust, privacy, you're in control. The people meant to protect you already lost, and they called it a win. Apple's analytics team knows which persistent identifiers cluster around sensitive behavioral contexts. Medical conversations, financial discussions, domestic arguments. That data has enormous commercial value. Apple says it doesn't monetize it. But who audits that claim? The same regulator that spent 4 years building a case, issued a fine Apple paid in a single afternoon and closed the file. Your voice is stored somewhere right now. The company holding it says it can't be traced back to you. They said that before.